Hello everyone. Today we will start a new series of Indian polity where I discuss about the key concept of Indian polity. So let's start. So the doctrine of procedure established by law originated in English constitution, that is Britain. So the procedure established by law, the law only become legal when the legislature followed a prescribed procedure. So, the doctrine of procedure established by law confer limited power on judiciary. Limited power on judiciary. So, there are three tests applied to test the law is valid or not. That is, the action of the state is valid or not. Test whether there is exist a law that authorize the executive to deprive an individual of his life and liberty. तो हमारे कॉन्स्टिट्यूशन में ये लॉ है जिससे कि एग्जीक्यूटिव है सो कॉन्स्टिट्यूशन ऑथराइज करता है एग्जीक्यूटिव को लॉ को लॉ को बनाने के लिए. द सेकेंड इज whether the legislature that enacted the law in question had the competence to enact such a law. जो legislature है कॉन्स्टिट्यूशन ऑथराइज करता है लेजिस्लेचर को लॉ इनेक्ट करने के लिए. Whether the legislature while enacting the law had followed the prescribed procedure. It means, let's take example, लोकसभा. लोकसभा में क्या होता है? फर्स्ट रीडिंग होता है, सेकेंड रीडिंग होता है, थर्ड रीडिंग होता है, देन फिर राज्यसभा में जाता है. राज्यसभा, इफ राज्यसभा passes the bill, then it goes to the president for assent. Then the bill become act. The court extend protection only against executive. If the court find law is arbitrary, oppressive, unjust, the court will not extend protection to the individual. So court will not extend protection against legislature. So the doctrine of procedure established by law extend protection only against the arbitrary action of the executive. Now we will proceed to due process of law. So the doctrine of due process of law originated under US Constitution. So it originated under American Constitution. So the due process of law gave wider power to the judiciary. Gave wider power. So examine and check the fairness and justness of the law with a point of view of natural justice. With a point of view of natural justice. So it extend protection against both executive and legislature. If the court find it to be the arbitrary or oppressive, it will declare the law invalid and extend protection to the individual not only against arbitrary arbitrary action of both executive and legislature. So the key point here is so the key point of due process of law is it confers the wider power to the judiciary where the court where the court check the fairness and justness of the law with a point of view of natural justice and extend protections against both arbitrary action of executive and legislature. So the procedure established by law is a English constitution came from a Britain, and due process of law came from American constitution, which is US constitution. So due process of law is a wider power on judiciary, and procedure established by law is narrow power narrow power on judiciary. So difference, now we will study difference. Key difference. Okay, so procedure established by law, due process of law. So the first difference is this is Britain constitution, this is American constitution. The second is narrow power on judiciary. In due process of law, wider power on judiciary. The difference is it will extend protection only against executive. Here, extend protection against both executive and legislature. So these are the key differences of procedure established by law and due process of law. So due process of law check the fairness and justness of the law by natural justice. Now we will study Article 21, which is right to life, which is also called protection of life and personal liberty. So Article 21 declare that no person shall be deprived of his life or personal liberty except according to procedure established by law. It means legislator can pass unfair law, unfair, unjust law by prescribed procedure. So, in Gopalan case 1950, the Supreme Court has taken narrow narrow interpretation where it held that the protection under 21 is available only against arbitrary action of the executive. So in Gopalan case, Supreme Court has taken narrow interpretation where it held that under Article 21 is only against is only available against arbitrary action of executive, not the arbitrary action of legislature, and not arbitrary action of legislature. It means it means it means the legislator can deprive it means the legislator can deprive the individuals according to Article 21. But in Menka case 1978, Supreme Court has taken wider interpretation wider interpretation where Supreme Court overruled its judgment. It ruled that right to life and personal liberty of a person can be deprived by law, provided that procedure prescribed by that law is reasonable, fair, and just. The procedure prescribed by that law is reasonable, fair, and just. Supreme Court has inserted due process of law in intrinsic but in Article 21. So so after Menka case, Supreme Court held that the protection under Article 21 should be available not only against arbitrary action of the executive but against legislative action. So available against both executive and legislature.